We would like to start the formal hearing portion of this hearing today. And we have several docketed items. The first docketed item is docket number, well, I need to back up. Today, we have most of the board members in attendance virtually. Ms. Davis is here in the building with us. Mr. Brown, Ms. Garrison, Mr. Church, Mr. Moon are in attendance virtually. The only board member I believe we're missing is Mr. Borden. Did I miss anybody? I don't think so. So the only member of the board not here today has been excused is Mr. Rich Borden. And now I'll go on with the docketed items, assuming the court reporter can hear me and is prepared to go ahead. If you could just give me a thumbs up to indicate you're ready. Great, thank you. First docketed item is docket number 2019-014, cause number C/007/0045, in the request by the Utah Division of Oil, Gas, and Mining to forfeit the reclamation surety in order to complete reclamation of the Wellington dry coal cleaning facility permit number C/007/0045. The board heard this matter in the July hearing, and the board took this matter under advisement and had asked the board council to do some research on this matter, and they have completed it and provided this information to the board for their consideration. We believe it's important that we consider this matter, and we would like to have a discussion among the board members this time. However, we would have to go to the other site that is provided for board members to have this deliberation in private. So board members, if you would, proceed to the other website that allows us to have our deliberations in private, and we can discuss this matter, and we'll come back and go on the record with our determination. Is there any comment from the other members of the board or council? If none, let's see if we can go into deliberation, and we'll be back as quickly as possible. Thank you.
How are you doing, Levon? You must be muted, kiddo. I can't hear you.
Mike and Levon, I think you're still on the public board page.
Oh, really? I thought I'd logged off. I'm sorry. Try and do it again.
Your face showed up again, Mike.
we're ready to go back on the record. Michelle, Ms. Court Reporter, are you prepared to go back on the record? Well, to record? Thank you. I'm just keen to make sure all the board members have made it back onto the site. I see Gordon and Steve, Levon. Is Mike Brown there?
I'm here.
Ah, there you are. Sorry. And Miss Davis is here with us. The board has deliberated on this matter, and I would entertain a motion to grant or deny the division's motion for reconsideration at this time.
I move to deny the division's motion for reconsideration pending in this matter.
Is there a second?
I'll second that.
Thank you, Mr. Moon. Discussion on the motion. Is there any discussion? Seeing none, we'll take a roll call vote. Ms. Carter, could you call the roll call vote?
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. Levon Garrison, how do you vote? Ms. Levon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon, how do you vote?
Yes.
Thank you. Mr. Chairman, I have 6 affirmative votes.
The matter has carried by unanimous vote of the present board members, and I have asked Mr. Mike Brown to read a brief statement as to the reasoning of the board in this matter. Brown?
Thank you, Mr. Chairman. Michelle, I want to make sure you can hear me. That could just be confirmed. The court reporter, can you hear me okay? I can't see her, Mr. Chair, so if she's giving you a thumbs up, let me know.
Michelle, can you hear Mr. Brown?
I can hear him. Yes, thank you.
Great, thank you.
Ladies and gentlemen, the division has shown that coal mine waste can only be disposed of at permitted areas. Excuse me. Sorry, let me re-begin here. The division has shown that coal mine waste can only be disposed of at permitted areas approved by the division, and to do otherwise is a violation of division's coal rules. However, the division has not shown the tests as articulated in appropriate legal authority presented in their motion for consideration have been met. In fact, upon detailed read of the applicable case law presented, the board's decision to deny the use of forfeited bond money to reclaim offsite unpermitted areas is actually supported. So to summarize, it remains the board's position that forfeited bond monies in this cause cannot be used to reclaim the coal mine waste moved offsite. As painful as we recognize this decision is, the board originally ordered the division to seek and use other civil remedies to reclaim this unpermitted material. This remains our position as originally directed. Thank you, Mr. Chairman.
Thank you, Mr. Brown. That concludes this particular docketed matter. If we can, let's move on to the next item.
Chairman Hansen, this is Haley Souza. Do you mind if I just jump in really quick and make one brief request of the board?
Ms. Souza, I believe the board has made its decision.
This has nothing to, it goes to the reclamation piece. It's separate and unrelated, but it is something that the board does need to rule on. And so if I could just take a couple minutes really briefly with the board's time to make this request, I would greatly appreciate it.
Okay. Go ahead.
The Cole rules specifically require that if a surety is forfeited, that those funds be directed to the division and the division must complete reclamation. In this case, Iron Shore, the surety of record, wishes to complete the on-site reclamation. But because of the way the Cole rules are drafted, they are no longer allowed to complete that, but the division is in support of allowing them to be lead on the reclamation, given their expertise in the area. And so the division would like to request the board specifically authorize that Iron Shore be allowed to conduct the on-site reclamation as opposed to the.
Okay. Is there a representative of Iron Shore that would like to make a statement?
Yes, thank you, Chairman Hansen. So I'm Josh Sundloff, counsel for Iron Shore. I've had conversations with Iron Shore about this in the somewhat distant past. Since the last board meeting, we haven't talked specifically on this. We're waiting for the board's decision. But my previous conversations were that Iron Shore was open and willing to perform the reclamation on site if after investigation they determined that that was a route that they wanted to do. I mean, at the end of the day, they're either looking, can they perform it and accomplish all the division's desires for less than their bond amount, or if it's going to be more than the bond amount, they'll just forfeit the whole sum. And so I think they're open to it, but I don't know that I can commit them without having discussed now that we've heard the board's decision.
Well, I was just talking with our counsel and asking how to proceed with this, but from what I just heard you say, while the division is asking us to allow Iron Shore to perform the on-site reclamation, you're saying you need to go back to your client and confirm that they're willing to do this. Is that what I understand?
I mean, that's the long story short. What I can say is my previous communications is yes, I think they're open to that. But I again, having heard the board's decision, I want to confirm that with them. Yes.
Okay. Is it appropriate then to make a motion that how do we do this so that we don't leave this open? Yeah, Sousa.
Can I suggest that the motion be phrased such that either the division or Iron Shore is authorized to use the surety funds to complete the reclamation?
Yep. If the division will accept that, I think we are willing to accept that. Board members, do you have any concerns or opinions on that? Seeing none, well, I guess then to finish this matter, it's appropriate for a member of the board to make a motion that either the division or Iron Shore be allowed to perform the reclamation on site. Is there a board member who would like to make that motion? Mr. Brown?
I just want to make a little discussion.
Sure.
Is it the board's duty to decide who does the reclamation? Isn't that just the division's duty, not ours?
In the oil and gas rules, that is the case, but with the coal rules, if the surety is to do the reclamation, it has to be done prior to forfeiture. And so in this specific matter, the bond has been forfeited in the board's original ruling. So the coal rules require that after forfeiture that the division conduct the reclamation. So in this case, in this instance, we are requesting the board to allow Iron Shore, should they decide that it's cost effective to do so and that they want to move forward with that, that they be allowed to conduct the reclamation.
I have a question, Mr. Chairman. Ms. Souza, given that we ordered the bond be forfeited, I'm a little confused because I heard Mr. Sundloff say they're hoping they can do it for less than the full amount of the bond.
Yes, so the division was awaiting a ruling on the motion for reconsideration prior to having Ironshore actually deposit the funds of the surety with the division. So currently Ironshore is still in control of those funds. And if the board wishes that the division be responsible for the on-site reclamation, then the division will request those funds and receive those funds from Ironshore. But currently, because we have not requested that they provide those to us yet, they are still in control of those funds. And if the board authorizes it, and if Ironshore determines that it's fiscally appropriate to do so, then they could conduct the reclamation and theoretically do it for less than the full bond amount, thereby saving themselves some cash out of pocket. Does that answer your question?
Yes, thank you very much for the clarification. I yield back, Mr. Chair.
Thank you. I guess we're back to the motion as to whether the motion making it possible for Ironshore or the division to perform the on-site reclamation. Is there a motion?
I am still confused. I think that that bond was forfeited and it should be the division's responsibility. If Ironshore is the low bidder, great. If they're not, somebody else should do it. But the bond should be forfeited to the division.
This is Josh Sundloff again. If I could add in a comment, Mr. Chair.
Please do.
My understanding, and if the board would like this, we can provide briefing on this. But my understanding is, I don't know how developed the law is in Utah on this score, but I know it's relatively well established in many states across the country that a surety bond, particularly in a reclamation bond like this, be given and has the right to perform. In lieu of forfeiture. So I think if the board were to make the motion to allow the bond, to allow Ironshore to perform the work subject to their decision, that would be in line with case law that I'm alluding to. That again, I can provide that to you. I just don't have it right here.
Thank you. I believe Ms. Davis and Mr. Brown have brought up some very salient points, and that we should probably investigate this a little bit more as a board as to how to proceed. If the board agrees, we can take this under advisement and come back on a ruling on how to move forward on this matter next month. If that's agreeable to the board. Have to make a motion to take this particular part of our ruling, or this matter rather, under advisement, since we've already ruled on the reconsideration matter. So at this point, perhaps a motion is in order to take this matter under advisement, if one of the board members would like to make that recommendation or motion rather.
So moved, Mr. Chair. Mike Brown.
Is there a second?
I'll second that, Mrs. Gordon.
Any discussion? Seeing none, Ms. Carter, could you call the roll?
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. LaVon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chairman, I have 6 affirmative votes.
Thank you. And Ms. Sousa, thank you for bringing that up, and Mr. Sunloff having those discussions. So we will consider how best to move forward. I appreciate the fact that this matter has been brought before us, and thank you for your patience so that we make sure we're taking the right steps and doing this properly. Now, I believe we can move on to the next docketed item. Next item is docket number 2020-005, cause number 379-01. In the matter of the the request for agency action of High Point Operating Corporation to set for investigation and a hearing to determine why Paradox Upstream LLC has not paid proceeds attributable to its overriding royalty interest on production from the Big Indian 24-31-30-25 well. At this point, I believe we are going to have the division just give us a brief update and report on this matter. Is there someone from the division that would be providing that information?
Yes, Haley Selzer for the division. Thank you, Mr. Chair. Yesterday, counsel for High Point filed a motion to continue. My understanding is that their agreement with Paradox required 3 installments, and on Monday, the 3rd and final installment was made, but there is apparently still one provision of the agreement that remains unfulfilled, and so the counsel for High Point filed a motion to continue until next month to allow Paradox to fulfill that remaining term.
And that motion to continue was received last evening. Is that correct?
Let me double check on my emails. I believe that it was Monday, but it may have been yesterday.
Okay. I've not had a chance to review it, and our counsel has not had a chance to review it, so we will and make a determination on that fairly quickly. If there is no further discussion on this matter, we can move on to the next docketed item. Let me put my glasses back on. The next docketed item is docket number 2020-013, cause number 191-08, in the matter of the request for agency action of Running Foxes Petroleum Corporation, aka Running Foxes Petroleum Inc. It is my understanding that this matter has been withdrawn. Is that correct, Ms. Sousa?
That is my understanding as well. It was refiled for the September docket, and it is currently scheduled for a examiner hearing on September 15th.
Okay, thank you. So it'll come before a hearing officer. Thank you. The next item on the agenda is docket number 2020-015, cause number 076-02, in the matter of the notice of agency action by the Utah Division of Oil, Gas, and Mining seeking an order forfeiting the reclamation bond provided by Patmos Energy LLC for the CBM 1 well. It is my understanding this matter has also been continued to the next hearing. Is that division, is that correct?
Yes, that is.
Okay, thank you. We're moving right along. The next item on the agenda is docket number 2020-017, cause number S/057/0010, notice of agency action by the Utah Division of Oil, Gas, and Mining seeking an order of one, withdrawing the notice of intent to commence small mining operations for Pine Ridge Excavation and Landscapes, permit number S/057/0010, and two, forfeiting the reclamation bond provided for the Pine Ridge mine, and three, authorizing the division to use the amount forfeited to reclaim the surface of the Pine Ridge mine located in Weber and Cache counties. I believe this matter has been dismissed without prejudice. Is this also correct, Ms. Sousa?
Yes, Mr. Chairman, this is Gordon Rowe. I'm handling this matter, and it was dismissed with prejudice, and we refiled, and it'll be coming under a different caption, hopefully next month.
Thank you. I apologize for not recognizing this was your matter, Mr. Rowe.
No, it's understandable. Haley's got a lot this month.
Mr. Chairman, one point of clarification. Gordon,
Yes, sir.
did you say dismissed without prejudice or with prejudice?
Without prejudice, meaning we can refile, and that was
Thank
granted.
you. Thank you.
Thank you. I believe the next matter might take a bit of time, this matter being the reef mine. And it may be appropriate then to take a break at this time. I guess one of the questions is, it is 11:30. Is this an appropriate time for everybody to take their lunch break? Let's do that. Let's take our lunch break and be back here at 12:30. So we will go off the record and reconvene at 12:30. believe we'd like to go back into session. Michelle, are you ready to go? Great, thank you. Let me make sure that we have all our board members still still attending. I see Mr. Church and Ms. Garrison, Mr. Brown. Just looking for Gordon Moon. Are we missing Mr. Moon? We're missing Mr. Moon, but I think we can go ahead and proceed. He may be able to join us as we go forward. The next docketed item on our agenda is docket number 2020-019, cause number S/015/0094, in the matter of the notice of agency action by the Utah Division of Oil, Gas, and Mining seeking an order of 1, withdrawing the notice of intent to commence small mining operations for the reef mine, S/015/0094, 2, forfeiting the remaining amount in the reclamation bond provided by Southwest Stone, Inc. for the reef mine, and authorizing the division to use the amount forfeited to reclaim the surface of the reef mine located in Emery County in Township 20 South, Range 8 East in Section 32, and 3, requests the Attorney General recover the division's assessed penalties resulting from several violations. But this time we would take appearance of counsel.
Haley Souza for the division.
Thank you. Is there anybody present representing the reef mine or Southwest Stone Incorporated?
The attorney representing Southwest Stone, Mr. Devin Snow, contacted me immediately into the lunch hour and informed me that he had competing obligations this afternoon and would not be available. And so he asked that I present the settlement agreement that Southwest Stone and the division have reached, and that the board has questions or concerns with that settlement agreement. He asked that I request a continuance to next month so that he can be present to address those concerns by the board. He asked that I please apologize on his behalf.
We accept the apology, and Ms. Sousa, if you'd like to proceed.
The division, so this settlement agreement was only reached yesterday afternoon, so my apologies for providing this information to the board so late. But yesterday afternoon, the division and Southwest Stone came to a mutually acceptable agreement to settle this matter. So as stated from the caption, the division was seeking forfeiture to complete reseeding of the reef mine and also seeking authorization to recover past due penalties. So under the agreement that the division filed yesterday, Southwest Stone has agreed to pay $5,000 in penalties and has agreed to complete the seeding no later than November 30th. And if Southwest Stone has also agreed that if it fails to complete the seeding by November 30, that it would be subject to the order also filed with the board yesterday, wherein the bond would be automatically forfeited and Southwest Stone would be subject to an additional $10,000 in penalties. So both the stipulation and the order that was agreed to by both parties has been filed with the board as of last night, and the division requests that the board stay the current proceedings until after November 30th to allow Southwest Stone to comply with the stipulation.
So you're asking the board to stay the current the current order.
No, the current proceedings.
Proceeding. I'm sorry. Trying to take too many notes and missing the important information. Is there any discussion before we move forward on this? Is there any questions, I guess, you'd like to ask Ms. Souza, board members? I see none. At this point, I guess it would be appropriate then to entertain a motion to stay the current proceedings as requested by the division in this matter.
So moved.
A second?
I'll second that.
Any discussion? Seeing and hearing none, we will go ahead and ask Ms. Carter to call the roll vote.
Mr. Chairman, this is Director Baza. Before
Yes,
you
sir.
do that roll call vote, Levon Garrison just informed me by phone that she has lost internet service. So she's trying to restore that right now, but I wanted to let you know.
Thank you. We'll wait until she's back on to have the roll call vote. Sure. Yes, please. Just to inform those who are unaware, we lost one of the connection to one of our board members, and we're trying to reestablish that before we have the vote. So we will we'll wait for a few more minutes.
Hello. Hello.
We can hear you, Levon.
Oh, okay.
Great,
Yeah,
thank
the
you.
power is off. The power is off at my house. I don't know what's happened, but go ahead and proceed.
Thank you. I think Ms. Carter, go ahead. We've reestablished that contact.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. Levon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chair, I have 6 affirmative votes.
I understand that we have a unanimous vote on this matter, and I assume that the appropriate document will be prepared by Ms. Souza in this matter.
All the appropriate documents are so far on file with the board. So following November 30th, so long as all of the requirements in the stipulation are met, then the division will be filing a motion to dismiss.
Okay, thank you. You're right. We need to, the board needs to receive those first. We'll move on to the next docketed item. Docket number 2020-020, cause number RMNRL-20201, in the matter of formal rulemaking to amend the mineral program rules pertaining to small mine operations resulting from Senate Bill 131. I believe we'll have an update provided by the division.
Thank you, Mr. Chair. We would like to combine this matter also with the next docketed matter so that we can walk through both of those rulemaking items at the same time. So I just wanted to start out by noting that, so as Director Baza briefed you guys on during the briefing session, SB 6004 puts a pause on rulemakings that aren't required by statute, but these two rulemakings that are before you today are required by statute. So these two are not paused, which is why we are continuing forward with those. And Dana will provide the specifics on the changes to the rules, but in each new rule, in each of these rules, it's implementing changes to the definitions that came about through the changes in statute during the last legislative session. So prior to bringing these to the board today, the division did engage with external stakeholders on these changes, and all are in agreement that the changes are necessary based on the statutory language. So I will now turn the time over to Ms. Dean so that she can present the specifics on the language changes that we are requesting to be made.
Thank you. Dana Dean, Deputy Director for Mining. Paul Gedge, do you have my PowerPoint presentation? Or Michael?
Dana, we're having a little bit of trouble here on the audio side, and Paul's working on that too.
Okay. Do you want me to wait, or can you hear me?
Dana, this is Paul. We have your presentation up before those in the video conference and those participating remotely via YouTube. If you'd like to go ahead and proceed, I will continue just with audio. We're still tracking down the source of the interference.
Okay, thank you. This is as Haley explained, these are some proposed minerals program rule changes. Next slide, please. The first bill that was run in the general session of 2020 to change the minerals program was SB 131. This was sponsored by Senator Hinkins, and it increases the size of small mines by definition. Previously, small mines were up to 5 acres in an incorporated area of a county and up to 10 acres in an unincorporated area. They will now be up to 10 acres in an incorporated area and up to 20 acres in an unincorporated area. Sorry. And there are some other small definition changes with SB 131. Next slide, please. These are some red line strikeouts of the rules. There are a few changes to R647-1 definitions. Again, that we're exactly copying the language from the bill. This changes the definition of disturbed area and changes the 5 and 10 to 10 and 20. Exploration, I'm not sure why this was changed, but this is what the statute said. It took out that it's not limited to and added the and. Next page, please. Large mining operations, the definition changed again. The 5 and 10 were changed to 10 and 20, and the same in the small mine definitions, and changed the word less to fewer to be more grammatically correct. Next slide, please. This also allows for a change to the small mine rules. When someone wants to enlarge a mine, they now can enlarged to 10 acres in an unincorporated area, or an incorporated area, and 20 in an unincorporated area before they have to file a large mine notice of intent. Next slide, please. And then revisions. This will also allows a large mine that is smaller, that would fit into the small mine category now, can get their NOI released as a large mine and go to a small mine. Next slide, please. Then HB 294 was sponsored by Representative Brooks. He's out of Southern Utah, and his idea was to exempt certain types of basalt operations that are common to his constituents, where they feel like they're just removing material that's in the way of building and developing in the area that he covers, and it made some other small changes to definitions of sand and gravel. Next slide, please. So this has some more definition changes. It adds a definition for basalt. I'm not going to read it, but I will tell you that we may be back after the 2021 general session with a different definition of basalt, but for the time being, we're changing it to the definition that's in the statute. Some issues were brought up after the bill passed with the language by geologists. It adds the definition under deposit or mineral deposit that a basalt, if it meets that basalt definition and it's less than 50 acres, then it's not considered a deposit or mineral deposit and will not be regulated by the Division of Oil, Gas, and Mining. Next slide, please. These are the small changes to sand and gravel. They changed from 2 to 4 millimeters, and I can't read, sorry, I can't read. Anyway, they just did some small changes to sizes. Again, and then mining operations excludes basalt operations, and they made another small change to sand and gravel. So these are all small changes. I think the basalt is the bigger change. We estimate that it impacts around fewer than 10 operations in the state, and the changes in small mines also affects around 10 currently permitted operations, but people could start new small mines, and small mines are a lot easier and quicker to get permitted than a large mine. So if they're looking at operating up to 20 acres, they could get a permit a lot quicker under the small mine rules. So this doesn't impact a lot. We have not seen a lot of new applications for these small mines at the larger size. So we don't really know if it will be a huge impact. It has been an unusual year for business, so we'll have to see in the future how this affects the division. And that's all I had. If you have any questions, I'd be glad to answer.
Thank you, Ms. Dean. Are there any questions that anyone would like to ask Dana? Ms. Davis.
On the basalt issue, you mentioned that it was specific to the representative's area. What is he trying to accomplish?
Again, just I don't want to speak for him, but in meetings that we had with him, there was a mine that we had asked to get a permit, and he felt like that type of mining did not need to be permitted because the end use of the land will be housing developments, and they were just moving this material out of the way, not really making a profit on it, and they're just the end use of this land is for development. And so that's what he was thinking, as far as I know. And he tried to make the language as narrow as possible, but that's one reason why we may be changing the definition slightly in the future to make it as narrow as we need it to just cover what he wanted to and not something unintended.
Thank you.
Thank you for that clarification. Any other discussion on this particular rule? Seeing none, I'm not sure. Would Ms. Sousa or Ms. Dean continue?
I can go ahead. Thank you, Mr. Chair. So at this juncture, the division is ready to request the board authorize it to initiate formal rulemaking for these two rules. And if authorized, Natasha Balliff, who is the division's legislative and policy coordinator, will work with the Office of Administrative Rules to ensure these rule changes are published in the state bulletin on September 15th, which will open a 30-day comment period.
Okay, so you're asking the board to move these rules to formal rulemaking, but as a matter of housekeeping, I should probably indicate that we have discussed both rulemaking matters under agenda item 7, and I have not yet read into the record agenda item 8, which I can do right now, and then we can entertain the motion if that's acceptable to you, Ms. Sousa.
Yes, it is. Thank you.
The other docketed item we just discussed is docket number 2020-021, cause number RMNRL-2020-2, excuse me, in the matter of formal rulemaking to amend the mineral program rules pertaining to mining operations resulting from House Bill 294. Now, having read that into the record, the board will entertain a motion to move these two rules to formal rulemaking. Is there a member of the board would like to make that motion? Anyone?
Mike Brown. Mr. Chairman, I'll move that these two rules be moved to formal rulemaking as requested by the division.
Thank you. Is there a second?
I'll second that.
Thank you, Ms. Davis. Any discussion on this motion? Seeing and hearing none, we'll ask Ms. Carter to take the roll call vote.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. LaVon Garrison, how do you vote? Ms. LaVon Garrison, how do you vote? Have we lost?
LaVon, if you could do a 6-star mute. *6 mute.
Oh, there we go. Yes, sorry.
Mr. Chris Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Thank you. Mr. Chair, I have 6 affirmative votes.
Thank you. The motion is passed. At this point, I guess we just let the division move this forward into formal rulemaking. At this point, we have one more docketed item, and I believe we need to take just a few minutes to go off the record and take a break. We need to wait for one of our members of council to come back. So if we could just take a break until say 1:05, we'll go off the record until then. Okay, we're go back on the record, but first I wanted to check to make sure. Levon, can you hear us? Levon? Okay, we'll wait just a moment while Paul dials her back in. We're not quite ready to go on the record yet.
Hi. Hello there.
Can you hear us?
I can't.
Okay, we've got you, and then we'll go back on the record as soon as I confirm with the court reporter she's ready to go.
Okay.
Okay, we're ready to go. We're back on the record. The final item on our agenda today is docket number 2020-003, cause number 479-01, in the matter of the request for agency action of the Betty T. Bowden Trust to set for investigation and a hearing to determine why NADK LLC has not paid proceeds attributable to royalty interests on production from the Alta 51B well and the Alta 5-2-C well. At this point, we'll take appearances of counsel.
Haley Souza for the division.
I'm Daniel Sam, appearing on behalf of Alberta Gas, who's an interested party.
And you're your attorney representing them?
Yes.
Okay, thank you. And I'm sorry. Any other parties that would wish to participate in this matter?
I'm Dave Knowles, here representing NADK.
Deanne, excuse me, sir. Deanne Kazik, representing the Betty T. Bowden Trust.
And Lorraine Oliver, representing the Betty T. Bowden Trust.
And I assume that that you and the others will be wanting to make statements, Mr. Knowles. So if that's the case, we would like to have you sworn in at this time. And could the court reporter swear these folks in as witnesses? You'll have to unmute your.
There we go. Thank you. Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
I do.
Okay.
Thank you. I need to make one more statement on this matter. It's the board has issued an order to show cause on this matter for the essentially to give us an update on where we are in the process and if and why payments of unpaid royalties have not been made as promised in the last hearing. And that was part of the order that we issued in our last hearing. So having said that, Vision, would you like to proceed?
Thank you, Mr. Chair. I've been asked to provide a summary of events that have occurred since the board's June hearing, wherein the board ordered NADK to make a full accounting and to provide full payment no later than September 22nd, 2020. So on August 3rd, the division issued a notice of violation to NADK because the wells had been shut in for over a year without approval. The NOV required NADK to either submit a sundry for intent to plug or submit a sundry for extension of approval no later than August 21st. To date, the division has not been contacted regarding that NOV. On August 6th, a field inspector notified the division via email that the NADK signs on the site had been removed and have been replaced with signs for Alberta Gas Company, and that the wells were in production. Following receipt of this email, further interactions with field staff indicate that due to competing priorities, previous inspections of the wells from earlier in the year hadn't yet been entered into the division's system. An inspection conducted in March of this year showed that while the well was not pumping at the time, the production valves on the wellhead and on the tank were open, indicating recent production activity. The inspector also conducted an inspection in June, in which the inspector observed the wells were idling and that the NADK signs had been removed, and there was also a trailer on site marked with Alberta Gas Company. The inspector again visited the wells on August 4th and noted that the wells were producing at the time of the inspection. The inspector noted that Alberta Gas Company had put up new signs and that the production valves on the wellhead and the production tank were open. Following this email interaction with the inspector, later that same day, division staff spoke with Mr. Dave Sweat from Alberta Gas Company and then his attorney, Mr. Daniel Sam. The division was told that through a lawsuit, Mr. Sweat had taken over ownership of the wells. It wasn't until yesterday that Mr. Sam provided the division with the complaint that was filed in the 8th District Court in May of 2019, seeking transfer of ownership of the wells back to Mr. Sweat, among other relief requested. Because the division hasn't seen any settlement agreement or other final resolution through the court, to the division's knowledge, the lawsuit is still pending. It's unclear to the division how or when Mr. Sweat took over operations of the wells. And if the wells have changed ownership, the division has never received any documentation on the change of operator. And Mr. Sweat has not posted any bond for the wells, despite several communications from division staff to Mr. Sweat and or Mr. Knowles. Additionally, Mr. Sam informed the division that a settlement is pending, but that the settlement does not include payment of past due royalties to the Bowdens. The division inspector again visited the site, the wells, on August 18th. And in response to staff telling Mr. Sweat that the inspector had witnessed the wells in production, Mr. Sweat told division staff that he was only testing the wells. But during the August 18th inspection, the inspector noted that for the Alta 52C well, the production valve was open at the wellhead and open into tank number 2. The inspector could hear fluid rushing into tank number 2. Additionally, the inspector witnessed that the burners on tank number 2 and 3 were lit and heating the filled production tanks. For the Alta 51B well, the inspector witnessed that it was pumping at the time of the inspection and was producing into tank number 3. The producing line was open at the wellhead and at the inlet of the production tank. Fluid was heard entering the tank at a high rate. The thief hatch on the top of the tank was open, and the inspector saw fluid flowing into the tank. Additionally, there were sell tickets in the mailbox that show sold oil and hauled water by Dave Sweat. It is the inspector's opinion that these wells have been producing since at least March of 2020, despite production being reported to the division as 0 between June 2019 through May of 2020. The division is unaware of whether Mr. Sweat or Mr. Knowles was responsible for the production in March that the inspector spoke of. Also on August 18th, Mr. Knowles submitted invoices to the board without any indication as to what they represented. The division can only guess as to that they are a piece of the accounting that is required to determine the full amount of the royalty owed to the Bowdens. But without anything from Mr. Knowles, the division is wholly unsure what, if anything, to do with that information. And also on that same day, the board received a letter from Mrs. Kazik asking that the wells be shut in until another operator can take over the wells. However, the division doesn't have authority to require the wells be shut in or to require a change of operator. So that takes us up to today of the recent events, and this completes the division synopsis.
Thank you. Obviously, this is a bit concerning, hearing this report that there's some things going on here that obviously there's no reporting. Things may not be going as the way we had asked in our, or had instructed in our last order, but again, I say this is very concerning. Are there questions from the board members that you would like to ask Ms. Haley at this time, Ms. Souza at this time? Seeing that there are no questions at this time.
Mr. Chairman, could I make a statement?
Just a moment. We need to reconnect with one of our board members. Levon needs to, Levon, if you would do a *6 on your cell again. It looks like she might.
Yeah, I'm back at the meeting. Power is on.
Okay, great. Thank you. Hold on just a moment. If we could hear from Mr. Sam at this time on this matter.
Yes. Yeah, I've had the opportunity to discuss this matter with Mr. Sweat over the last couple of weeks, and have been in contact with Mr. Knowles and NADK's attorney over the last month. We are in the process of working out an agreement, hopefully, that will involve the transfer of the wells back to Mr. Sweat. Mr. Sweat operated the wells up until May of 2017. And then pursuant to the agreement with NADK, he, and when I say he, Alberta Gas, transferred operatorship, maintenance, operations to NADK pursuant to their agreement. Mr. Sweat hasn't had any operating experience or knowledge regarding these wells from May of 2017 through July of 2020, when we began working through this agreement to resolve the lawsuit. At that, we had a hearing with Judge Peterson in July, around the 10th or 11th. I can't remember the exact date, but at that time we were informed by the counsel for Mr. Knowles that we basically had an agreement in principle that the wells would be going back to Mr. Sweat, that we would be working on paperwork to make those transfers. We haven't exchanged any paperwork yet, but is anticipated that we will be doing that shortly. My understanding is that Mr. Sweat did go and inspect the wells, and these wells, in this group of wells, there are also some BLM wells where there were compliance problems, some cleanup that needed to be done. Mr. Sweat has been out there cleaning these wells up, is my understanding. He also put, he's tested them, and he put, I believe, the 2 wells that we're talking about in this case back into production starting end of July or first part of August. He fully intends to properly report all of the production and to segregate funds for the payment of ongoing royalties as required going forward, as he had done in the past prior to 2017. That's my understanding of where we are right now. We just haven't consummated the deal, but Mr. Sweat has received pressure from compliance officers regarding the wells in order to keep them from receiving plug and abandonment orders from the various authorities. He has done operations on the wells, including cleanup, testing, and other matters. So that's basically where we are at this point. He does not intend to pay past royalties. It wasn't he until he received the notice of the order to show cause that I also received a copy of. He wasn't aware that there was an allegation of unpaid royalties. And the burdens that he understands exist on these particular wells, which are upwards of 20% or higher, would make it unworkable if he were to have to assume responsibility for unknown operations over the past 3 years, and without knowing whether or not royalties had even been paid. So for him to continue to operate these wells, he wouldn't be able to do it on an agreement to assume unknown, unpaid royalties and unknown operations, production that has occurred during NADK's operatorship. And that's my statement.
Thank you. Just to be clear, Mr. Sweat does not intend to pay past royalties due between May 2017 and late July 2020. Is that correct?
That's correct. And he doesn't believe that we could have a settlement agreement if that were to be the requirement, that he would not be able to assume operatorship of these wells if that was a requirement, because it's virtually impossible for him to know what's been paid and what hasn't been paid without an accounting.
May I speak?
Well, hold on for just a moment. I think we're digesting this latest issue a little bit about.
I think I can clear it up.
Okay, go ahead.
So since I last reported production, I have not produced anything from those wells. Haven't sold anything. I haven't even been out there. So I haven't been able to pay for gas to drive out there. And as far as this agreement with Sweat, I haven't seen anything in paper. And my understanding was that he would pay past due royalties and the taxes. And that was what I believed it contingent on. And if that doesn't work for him, then I guess it doesn't work. But that I haven't produced those wells for over a year. I haven't sold anything off of them. And what I supplied to the state for production numbers, the last thing that they received as far as production, that's accurate. I haven't produced them. If somebody's been out there and produced it, it wasn't with my knowledge or with my blessing. and we haven't, to my knowledge, we haven't reached an agreement and complete yet with Mr. Sweat, and I had no idea that this was going on. I had no idea that they were being operated. And,
Mr. Knowles, when was the last time you submitted a production report to the state on those wells?
I think it was I'd have to look at the record. I could get that, but it's been almost a year, or has been a year.
So
one moment.
The wells have been shut in for a year.
Yeah.
Okay.
Mr. Knoll, is there any paperwork showing the sale of these wells from Sweat to NADK and then perhaps back? Is there any paperwork that's out there that's signed by anybody?
There was a contract signed when NADK purchased the wells from Dave Sweat.
And was there any mention of royalties or anything in that purchase agreement?
No, not that I remember. And Mr. Sweat didn't have any information on royalties. And as I explained before, we tried multiple times to get that information from Summit Operating, and they refused to provide it for whatever reason. It wasn't until Bev Weiser emailed their attorney that they gave it, and that was.
So who was paying the royalties prior to 2017?
They were using so Dave Sweat was using a marketing company, which was Summit Marketing, which is a division of Summit Operating and the Summit companies. And they had it first. They were paying the royalties, and they had the information on the royalties, how much, where to send it, who it was. And that was the only source of the information that I knew about, or still know about.
Was that information provided to NADK?
No, not until Bev, the division, emailed their attorney, Larry Williams, and requested it. Before that, we never had any copy or any indication of what it was. Had no idea.
Okay. Thank you.
At this point, that Mr. Begley would like to ask a few questions, if he could. Go ahead.
Good afternoon, Mike Begley, counsel for the board. First with Mr. Knowles. Based on some comments made by Mr. Sam, there's negotiations with an attorney for NADK on involving the litigation that's occurring. Why is that attorney not before us today?
Because I can't afford to pay him.
But he is still representing NADK's interest in the settlement involving the litigation?
I think so. I think he's still communicating with Mr. Sam.
Mr. Knowles, I'm going to remind you that you're under sworn oath at this time. And is it think or did it happen? And is it happening?
Is my attorney speaking with Mr. Sam?
Correct.
Yeah, I don't know when he spoke to him last, but he is talking to him.
So, Mr. Knowles, you represented NADK before this board last month, is that correct?
Yeah.
Did you were represented by counsel?
I'm sorry, I couldn't hear you.
At any time during that previous hearing where under sworn testimony, did you represent to this board that you were represented by counsel?
No, I didn't.
At any time during your testimony before this board, did you indicate that there was a litigation involving NADK with Mr. Sweat?
No, I don't believe so.
Why was that information not disclosed?
There's several litigations going on against NADK. And I didn't know that it would be relevant.
Isn't it true that when you represented before this board that there was an agreement that would be paying the Betty Bowden Trust and the beneficiaries, that you represented there was an agreement in place, or that you would attempt to get
No.
in place, that they would be paid?
Yeah, what I had said is that there was a potential buyer, and it was not Dave Sweat, but he was unable or unwilling to follow through. And then I was told by my attorney that Dave Sweat would take over the wells.
Mr. Knowles, this involves the relief requested by the Betty Bowden Trust, and what the division has spent a considerable amount of time investigating and trying to negotiate here, involves about $10,000 during the period of time from December to May 2019. Where did that money go?
All of the proceeds from the wells went into the wells, including all of my savings.
Mr. Knowles, I'm referring to Mr. Knowles, I'm referring to the royalties that were derived from the production of those wells. So how did that royalties then go back into the wells?
Well, the royalties, I didn't know what the royalties were or who they went to. I tried to maintain money in the account, but I was just trying to keep them operating, and it was a losing battle.
If there's an accounting of that royalty, the royalties or the unpaid royalties that should be accounted for, would it be traced into your bank account individually?
No, absolutely not. I've taken no money from the company except for a small paycheck because I lived on location for 3 years.
This question is going to go to both Mr. Sam and Mr. Knowles. I heard the term unknown operations. And Mr. Sam, could you please describe to me what that term means?
What that means is David Sweat was not aware and had no ability to know what was going on between May of 2017 and basically the end of July of this year. Those operations were completely in the hands of NADK. That's what I'm referring to. And referring to royalties, David Sweat doesn't have any way to know what royalties would have been due during that time period. Prior to that, as Mr. Knowles had stated, the management of the royalty payments were handled by Summit Energy. It was, and as far as David Sweat was concerned, that was all handled appropriately up through May or so of 2017.
So what involvement does Mr. Sweat have with respect to Summit Energy? And why are they not before this board today?
Summit Energy was, I don't understand the full relationship there. They had some neighboring wells that they operated. They had some pipelines that I think that they ran gas through. I'm not fully aware or understand how that occurred, but Summit Energy may have also had a working interest in some of these wells. I'm not sure that at that time that they required that funds be managed through Summit Energy.
Ms. Souza, is this a situation that the division recognizes that the operator of these wells during the unknown operations time, is it NADK, Summit Energy, or Mr. Sweat?
That's one of the division's primary concerns, is because we don't know. The operator of record is NADK and has been since December of let me double check on that, 2017. But Mr. Knowles is stating here that he hasn't been out to the wells in a year, and the division believes that these wells have been producing since at least March. So it's incredibly concerning to the division that if the operator of record isn't producing these wells, who is producing the wells? And I'd also like to note that Mr. Sam said that Mr. Sweat has been on site since the end of July, but our division inspector noted that someone had removed the NADK signs as early as June 9th, and that an Alberta gas company trailer was on site as soon as June 9th. So it is concerning that there has been production that is not being reported, and there has been the sale of oil that has not been reported, and both parties are insisting that it wasn't them and that they know nothing about it.
So is Alberta saying they didn't produce those wells?
Pardon?
Is Alberta saying they did not produce the wells even though their signage is on the well?
No, I don't think we're saying that David Sweat is not saying that. He did begin producing the wells, I believe, in July, the end of July. And he has had, I think, one sale that he's keeping accurate records and will be paying royalties on those. That's what he's told me. So anyway.
Mr. Knowles, I have another question. The money that did come out of the well while you were operating it or are operating it, who paid you? If Summit didn't pay you, where did the checks come from?
So we had a different marketer, which was MC Oil. And they purchased our oil.
Okay.
And I currently don't have a contract with any marketer. And
Mr. Chair, if I have just do a follow-up question, please.
Yes, Mr. Begley, go ahead with your follow-up question.
Ms. Souza, and it'd be fine if you want to consult with Ms. Weiser. In the previous negotiations with the parties, did those negotiations involve Mr. Sweat, Mr. Knowles, and the trust?
Those negotiations only included Mr. Knowles and the trust. The division was unaware of Mr. Sweat's existence until just recently.
And Ms. Souza, is it fair to say then that when Ms. Weiser was negotiating or attempting to negotiate this, was there any discussion by Mr. Knowles to the division that there was a separate lawsuit that was occurring with respect to these wells or subject to these wells?
That information is also new to us in recent weeks.
And so is it fair to say then that the agreement that Mr. Knowles represented to the division had no knowledge that involved Mr. Sweat and or existing litigation?
Well, I believe at the June hearing, he did mention that Mr. Sweat was a party to that agreement, but at that time we had never seen that agreement. And it sounds like, hearing from Mr. Sam, that agreement still hasn't been hammered out. And there was a second part to your question that I haven't answered yet. Will you remind me what it was?
I actually think you anticipated, Ms. Souza. Is the agreement that was represented to the division between Mr. Sweat and Mr. Knowles involving the litigation, or was that just something Mr. Knowles represented that he was hoping to get? In other words, did it result from that litigation at all as represented by Mr. Knowles to the division, or was it just a separate consensual agreement?
A separate consensual agreement as what was previously represented to the division.
Thank you.
Ms. Sousa, just to be clear in my notes, the division believes the wells have been producing since March of 2020?
Yes, that is at least since March of 2020.
This is really quite disturbing.
Mr.
Obviously,
Chairman,
there's
this
been
is
no
Mike Brown.
royalties
Sorry.
paid to the Bowden Trust. And here we have somebody producing from a well and not paying the royalty owners. This is going to be a mess. Mr. Brown, go ahead.
I have a question for Mr. Sam, please. Mr. Sam, if I understood your testimony correctly, you said that Mr. Sweat had been producing from the well since sometime in July. Is that correct?
I may be wrong. It may be June, but that's when he has produced, but he's had one sale, as he's told me. That sale was at the end of July or 1st of August sometime.
So can you explain for the board and for the division how Mr. Sweat felt he had the legal authority to produce from the well at all, given the agreement, quote unquote, is in such a state of flux?
As far as we were concerned, the agreement was not in a state of flux. We had that hearing, I believe, like I said, July 11th, wherein it was, we had discussed between me and Dave Knowles' counsel that the wells were basically just being turned back to David Sweat, that he would assume the operations, that we needed to prepare the sundry notices, the assignments and other documents, and to complete the agreement. That hasn't been done yet. I have had some communication issues with Mr. Dance as well. I've reached out to him by email and haven't heard back from him, and maybe that has something to do with I don't know what the dynamics of representation there, but that's why Mr. Sweat felt that there were two reasons. Number one, the wells were in serious dilapidated state. They were in non-compliance with environmental issues, spills and other things that David Sweat went up and cleaned up under threat of orders from BLM and I believe the state of Utah as well. That he had been in communication with officers from both BLM and the state of Utah from that time period of July and maybe dating back into June as well. So he started cleaning him up, knowing that we had an impending agreement in order to save penalties, fines, potential P&A order to bring the wells back into compliance. So, but as far as oil sales, Mr. Sweat will, I'm sure, testify that there's been one sale, that sale is accounted for, that there will be royalties being paid out on those. I'm not sure that he's even received the funds yet on the sale, but that's, I hope that answered the question.
Thank you, Mr. Sam. I have a follow-up for Ms. Souza, please. Haley, can you vouch for the fact that the division issued some kind of order or threat to Mr. Sweat to correct the condition of the wells? It sounds to me like the division had no clue he even had any ownership interest or anything at the time. So I find Mr. Sam's testimony a bit confusing that either the BLM and or the division issued any kinds of threat to Mr. Sweat to correct the conditions of these wells that were not clearly in his ownership. There's something that's just not making any sense here.
The division did issue a notice of violation on August 3rd because of the shut-in, but let me pull up that violation really quick. I know that that was sent to Mr. Knowles. Let me double check to make sure that it wasn't also CC'd to Mr. Sweat, because I want to give you accurate information. So I'm getting close. Hang with me. Here it is. It was directed to Mr. Knowles.
Thank you,
And I
Ms.
do
Souza.
not see Mr. Sweat's name anywhere on it.
Thank you, Ms. Souza. Mr. Chairman, I yield back, but I agree. This is a massive confusion.
Can I also, Mr. Chair, may I please make one more comment?
Certainly, go ahead.
I received a notification from division staff who we think it's necessary to make sure that the record is very clear. The division cannot confirm actual production until June, but the valves were open in March, and open valves are generally indicative of production, but we cannot confirm the production was occurring in March. We can confirm that production was occurring in June and that the valves were open in March.
Okay, thank you for that.
If I can make one more statement too. This agreement involves a total of 7 wells. I believe there are 2 of them that are fee wells, and 5, I believe, are BLM wells. So there has been interaction between David Sweat and BLM enforcement officers, I believe. I'm not positive or sure that there are any state involved. It may not have involved these 2 particular wells, but Mr. Sweat's concern was the dilapidated state of all the wells. He had to go and do a lot of cleanup on all of them, and has done that and is in the process of doing it still, I believe.
Okay, thank you. This is a Gordian knot that we're going to pull the string on, I'm afraid, and figure out where this is going. But in the meantime, Mr. Gordon Moon, you have a question?
Yes. So Alberta Energy or Mr. Sweat, were they the operators prior to 2017? And were there any issues with unpaid royalties or notices and violations, et cetera? I guess my first question is, how long were they the operators prior to 2017? And second question, were they prudent operators?
Yes, they were prudent operators from prior to 2017, clear back to the early 2000s, 2002, or even earlier. Alberta Gas operated these 7 wells, including the 2 that I think are at issue here. There was, I believe, a gap between May 2017 and December, which I think Ms. Souza referred to, when the operatorship paperwork was not filed, changing it from David Sweat or Alberta Gas to NADK. So the actual operations were taken over by NADK in May of 2017, but the paperwork probably wasn't filed until December of 2017.
Yeah, and so
Can I actually
go ahead.
provide some additional information? Alberta Gas and Mr. Sweat have actually never been the operator of record in the division's files. According to the division, Summit Operating was the operator of record through November of 2017, and then in the division's eyes, NADK took over direct operations from Summit Operations. I did see a document yesterday in the well file for one of these wells describing the relationship between Summit Operating and Alberta Gas Company that allowed Alberta to produce from the wells while Summit Operating was listed as the operator of record. But I don't have that document in front of me. Division staff is working furiously to pull it as fast as they can, so that I can provide you with a more detailed description of that relationship. But in the eyes of the division, Dave Sweat has never been the operator of these wells.
It sounds like and then has with Summit to report and pay royalties. Is that not accurate?
I'm sorry, Mr. Mann, you were cutting out. Would you mind starting over?
I'm sorry. So it's kind of my understanding that Mr. Sweat or Alberta owned the wells, but then had Summit Operating paid the royalties, etc., and also apparently was the operator on record with the division. Is that correct, Mr. Sam?
Yes, that is correct, and I probably was not stating that correctly. David Sweat purchased these, I believe, from Summit Energy 20 years ago, and Summit maintained operatorship pursuant to their arrangement and handled the money clear until 2017 when they switched over.
Yeah, so my concern is we're getting a lot of details of exact timing of some production. What we have here, in my opinion, is a prudent operator operating the well. There was a sale, and then things fell apart. Now that prudent operator is trying to get ownership back and take over those wells. And I haven't seen anything that says that Alberta, Energy isn't going to jump back in and report and pay royalties and fix up these wells. So that's what I just wanted to understand, that in the past they've been a prudent operator. And I maybe have a question for the royalty owners that are on. Is that your experience also, that Alberta Energy or David Sweat or Summit altogether, that they operated these wells prudently and paid royalties? Are they on the two ladies?
I'm sorry, they're on mute. Go ahead.
Sorry about that. I do have knowledge of irregular payments from Summit Revenue Distribution.
Excuse me, but just for the record, if you could identify yourself, please.
Excuse me, Deanne Kazik, one of the trustees of the Betty T. Bowden Trust. I do have, like I said, knowledge of irregular payments from Summit Revenue Distribution is what the check says. The last one is for production on the 5.2C, dated 9/30 of 2017. This was just less than 4 months prior to my mother's death. And we started handling the situation. But I know in conversations with both my parents when they were alive, that payments were always very irregular. And my father, being a drilling consultant, said that he always knew that these wells produced more than was ever reported. My father drilled in the basin and all over in the Intermountain West for his entire life, as well as Alaska and in the UP. He went all over doing this stuff. So did he go out there and engage these wells? No, he did not. But I think this accounts for the valves being open since March of 2020 and no record of anybody doing any production. It's concerning. It's very concerning to us.
So you're alleging that not only NADK has not paid, I mean, the investigation has been related to NADK royalties, correct?
Yes.
But you're also alleging that Summit Operating or Alberta or David Sweat did not pay royalties?
The payments were irregular.
Okay.
I have not done an accounting of it, and I contacted Mr. Knowles personally in August of 2018 and made him aware of our ownership rights. So to say that he was unaware is wrong. I actually have the original lease and I provided it to the division of when my grandmother leased it out to Alta Energy Corporation in 1966. And it lists all of the owners and their varying percentages. So can I prove that royalties have not been paid adequately? No, sir, I cannot.
Well, we need to stick to what we've been investigating for now. So I
Okay.
yield, Mr. Chairman.
Can I also have one moment also to speak to the prudence of Alberta as an operator? I've been
Go ahead.
having communications from division staff indicate that Alberta has historically not been a very prudent operator. I don't have any documentation in front of me, but I'm being told that there are 56 pages in Alberta's compliance file. I've asked what that means, and I'm waiting to hear back still, but I just wanted to provide that in the eyes of the division, Alberta is not a saint either.
Yeah, and I guess our main concern here, this is a royalty question, and we want to get royalties paid. Now, in the interim, when NADK owned it, I don't know what we do there, but going forward, we want to ensure that that happens on production that, by Alberta Energy. So.
At this point, are there any other questions from the board members to either of the attorneys at this point? I'd like to give the Bowden T, the Betty T. Bowden folks an opportunity, the trustees an opportunity to present any kind of evidence or discussion at this time. If you'd like to make any further statements.
Thank you, sir. This is Deanne Kazik for the Betty T. Bowden Trust. I just want to make note that in my letter that I sent everyone on August 18th, that I hastily used the term plug and abandon. I think we would be more apt to say just capping the well or a shut-in until we can get these resolved issues in, because I know in the well files myself as to what Ms. Sosa said, Mr. Sweat lost his right to produce them prior to Mr. Knowles getting them because of non-compliance issues. Thank you very much.
Thank you for that. I believe, Gordon, go ahead.
Yeah, so production in June and July, when would that be required to be reported? Anybody know that?
My understanding is to be September is when that would be required.
Okay, so next month. So
yeah,
they're not behind on reporting yet, assuming that production was in June. First production was in June. If it were in May, when would that be? Anybody know? Okay, but Mr. Sweat is saying that the first production was in June or July. So, okay.
All right. I think at this point, the board should go into some deliberation. on this matter. And so we'll go off the record and ask that the board members log on to the website that allows us to deliberate. And we will be back as soon as we're completed with those deliberations.
Mr. Hansen, could I just ask one more question?
Sure.
Of both council, what would you suggest we do? What would you like us to consider doing when we go to deliberate here? Ms. Sosa and Mr. Sam.
That's a difficult question, Mr. Moon. I think I would need to confer with my client to really come up with a response to that question, but I'm happy to do that.
That would really help us because at this point, I'm a little bit, just personally, I'm a little bit confused as to what we really can do here to help the situation. And the other board members probably have great ideas, but I'd like your ideas.
If I could,
Sorry, go ahead, Mr. Sam.
Yeah, if I could just say a few things. I'm not aware of any non-compliance issues when Mr. Sweat was holding them. I do have some documents in my file that I hadn't reviewed, of course, before I came here, but I reviewed in the past that indicated that he was in compliance, that there were non-compliance, and I think that's I shouldn't say it's normal, but it happens now and then where they inspectors may go out and find this or that. David Sweat has always, as he's told me, has always been, prudent at getting those things corrected. As far as sporadic payment of royalties, I have looked at the production records on these wells going clear back to the early 2000s that should show that the production has been sporadic on these wells. And so it wouldn't be unusual to have sporadic royalty payments if production is sporadic. There are many reasons, I suppose, as to why it would be sporadic, maintenance issues and whatnot. But David Sweat relied on a third party, Summit Energy, to handle the funds. I believe that that's prudent. Going forward, he would like to, of course, have approval from the state to continue operations as he had done in the past. He's an approved operator with the various purchasers of oil that are out there. He's in good standing with the BLM. I believe he would be in good standing, or should be in good standing, with the state of Utah going forward as well. And he's just asking that he be allowed to continue operating these wells as he had done in the past.
A response on when production reporting is due.
I'm sorry, there's some huge feedback or something. Could you start over, Ms. Suzette?
Yes, I think the feedback was coming from Mr. Sam, but he appears to have fixed it. So for May production, that production reporting was due on July 15, and for these wells, it has been reported as 0. For June, the June production was due August 15th, and nothing to date has been received for that. And July production will be due on September 15th.
Could I ask you that? How much, what would you say average production from these wells is if they were on production? Are these stripper wells, or are they capable of more production?
I was going to say that also in my last comments, that these are stripper wells. David has had experience over the course of 20 years dealing with stripper wells, and believes and has had luck in making them economic through his experience, and he believes that he can continue to make this these two wells economic going forward.
So plus the 15 barrels a day. Is that right?
Under 15 barrels a day.
Are there any other questions before we go off the record again? Gordon.
Yeah, I'm sorry. One more question. So when these wells went to NEDK in May of 2017, was there an actual ownership change and therefore a royalty burden change at that point, Mr. Sam?
Yeah, my understanding was NADK put up a bond that replaced the Summit bond in 2017. And then from that time forward, it was the financial responsibility was with NADK.
Okay. Thank you. One last chance for Ms. Sosa. Any recommendations to us as to what you would like to see?
We're setting up a Google Hangout so that we can discuss what the division thinks would be the best remedy moving forward. But at this current moment, I don't have a recommendation for you, Mr. Moon. I'm sorry.
Okay, thank you.
Yeah, well, we can give you some time while we go into deliberation to come up with those recommendations.
That would be helpful. Would it be best to deliberate and then reach out to board council? Or how would you like us to get back in touch?
Please let us know when you're done, and then we can go back into session after, we'll be discussing it, you'll be discussing it. Let us know when you're done, and we'll come back on the record.
Perfect.
Any other questions before we go off the record? Seeing none, Michelle, we're off the record. And board members, let's move to the other website that we use for our deliberations. Looks like we're getting ready to go back on the record. I see that the board members are back. Michelle, are you set to go, court reporter? Great. Got the thumbs up. Before we went into deliberations, we asked the division to come back to the board with a recommendation, and I understand the division has a recommendation that they would like to give us. I assume that would be you, Ms. Sousa?
Yes, it is. Thank you, Chair Hansen. Consistent with the board's previous order, the division recommends that the board order NADK to do a full accounting and pay past due royalties to the Betty T. Bowden Trust for the period between December 2017 through May 2019, and that should be completed no later than September 22nd, 2020. Additionally, based on the information brought to the division's attention during this hearing, the division is very concerned about operations and potential illegal activity at the well sites. The division takes this information very seriously and will follow up with all parties to determine appropriate potential enforcement actions. If any illegal activity occurred, the division will seek all remedies allowed under the statute. In order for the division, or in order to ensure the division has all information possible in determining whether illegal activities occurred, the division requests the board order both NADK and Dave Sweat to provide any and all seal records and run tickets beginning between December 2017 through the present. This will allow the division to determine whether any oil or gas was sold during the time that production was reported as zero, as well as to confirm the production reports provided between December 2017 through May 2019. And I am done speaking.
Okay, thank you. I want to make sure I took notes fast enough. I understand that we would move that we issue the order that we proposed to back in June, and in addition to that, you're asking us to have NADK and Mr. David Sweat give a full accounting of production from the wells from 2017 to present?
Specifically, we want that accounting to be done through the production of run tickets and seal records.
Run tickets and seal records, right?
Yes.
Mr. Begley would like to ask a follow-up question.
Ms. Souza, is the division's recommendation that the proposed order granting the Betty Bowden Trust the relief that your division's recommending today to be amended to include that additional requirement for going forward, or is this a standalone order issued separately than to the proposed order before the board now?
I'm not certain the division has a preference, and so we'll leave that up to the board's discretion as to whether they believe it should be included in the proposed order or whether it should be a standalone order.
And I also have a question for Ms. Sosa. Do you have any, or does the division recommend any adjustments, additions, corrections to the proposed order?
No, the division believes that the numbers in the proposed order are likely accurate, generally accurate, and so we don't have any other additions to the proposed order.
So your request for field, et cetera, that pertains to time outside of the.
I'm sorry, Mr. Moon. Could you start over again? You cut out quite a bit at the beginning.
Okay, so
Sorry.
your request for field records and, authorization to get the field records, et cetera, that pertains to time outside of this unpaid royalty window.
That is correct.
Okay, got it.
However, if based on the production of those records that we're asking for, if it's determined that the production that was reported to the division that is the basis for the royalty payment is inaccurate or incorrect, then the division would expect to take additional actions to ensure that the Bowdens have the information they need to collect on those royalties as well.
Very good.
Are there any further questions from the board members for Ms. Souza? Now I'll try to state the motion accurately. The motion before us is to issue the order that we proposed in June and modify it to include the requirement that NADK and Mr. David Sweat produce run tickets and seal records from 2017 to present so the division can make a determination of the oil produced and to determine what royalty payments that are due. Would that be correct? I'm seeing some nodding heads. So if someone would like to make that motion, we can vote on it.
I would so move.
Is there a second?
Brown, I'll second it.
Thank you, Mr. Brown. Ms. Carter, could you take the roll call vote?
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Mr. Chris Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chairman, I have 6 affirmative votes.
Thank you. Ms. Souza, I would assume that you would prepare the amendment to the existing order.
I'd be happy to, Mr. Chair.
Thank you. I believe that concludes this particular matter. And
Would it be okay if I ask a question for clarification?
Sure, go ahead.
So when you say a full accounting, is that all of the company records? Is it just those 2 wells? Is it just oil sales? Or is it everything?
Could I hop in, Mr.
Yeah.
Chair?
Please answer that because you know what you have in mind.
The statute requires the full accounting for the purposes of determining royalty payments. So the information that's necessary in order to determine that this specific amount is how much is owed to the Bowdens is whatever is required for that accounting. And Mr. Knowles, to be clear, you are required to complete that accounting. We are not asking that you send in a bunch of documents to the board or to the division for the division to punch the numbers for you. The order and the statute requires that you complete that accounting and let the division know and the board know the results of that accounting.
Okay.
Great. Thank you, Ms. Souza. And I assume that answers your question, Mr. Knowles.
Yes, it does. And I have one more clarification question, if I may. So in the order, I'm supposed to pay the Bowden Trust the back royalties. What if I can't do that? I don't have any means to do that right now.
Well, unfortunately, from the board's point of view, we can't give you any recommendation on how you do that, but it is still stands in the order.
I don't want to be seen as ignoring the order or not complying with it, but I don't at this moment see a possibility in being able to do that.
Well, I'm sorry you're in that position, but the order stands that NADK owes that money to Bowden Trust, and however that goes forward between you and the trust is going to be your problem. I'm not sure what else we can tell you.
Okay, I understand.
Well, we have no further docketed items before the board for today. If there's a motion to adjourn.
Move to adjourn.
A second?
Second.
We are adjourned. So thank you very much and appreciate your attendance and interest in this.